This is an MS Views and News program. We call this MS Views Now. All right, we started this program series in the days of COVID, and we found how much it is needed to do something for the MS community with what's happening in current time, which is why it's now. All right, this program is supported by Sanofi. My name is Stuart Schlossman. Our guest tonight is Craig Dorne. Craig Dorne is from the law offices of Craig Dorne, Esquire. And Craig is a very well-known attorney down in the South Florida area. He does estate planning, real estate law, business law, and so much more. Okay, more. Okay, great. So we are going to listen to Craig speak tonight about, well, the topic set. You can see it on the screen in front of you. I don't have to read it. Let's let Craig talk about it.
As Stuart said, my name is Craig Dorne. I've been with MS Views since its original inception, and it's a pleasure to be with you all here this evening. My office is here in Coral Gables. I will soon be opening up an office in Central Florida as well, in the Orlando area. So I look forward to sitting down and being able to meet hopefully some more of you up that way as well. I've been doing this now for going on 35 years, and it's my pleasure to be able to share a lot of information with you today on medical and financial care planning. Now, people frequently ask me, when is the right time to do my financial and estate planning? And the truth of the matter is, it's never too early to do it. The problem is, if you try to do it a day late, it's not going to really come in too handy. So when is the correct time? It's pretty much as soon as you turn 18. And people say, well, why does it make a difference when you're at the age of 18? Well, at the age of 18, do you realize if you go off to college or whatever else it is, your parents can't make decisions for you anymore. So do you want a court, or who do you want to sit down and help you take care of your issues if anything does arise? So frequently I will help many of my clients start as early as the age of 18. So what is estate planning? Estate planning is taking care of not only your estate to help you in the event of your passing, it's also to help take care of you when the need arises and you're not able to take care of something for yourself. We like to create many different types of legal documents so that we can sit down and really take care of issues that may happen in the event you become incapacitated or in the event of death, so that we don't have to sit down and put a burden on or leave it to somebody else to make that decision. So what does an estate plan do? It addresses the disposition of your assets upon your death. It can sit down and help somebody to sit down and provide their authority to act on your behalf if you cannot act on your behalf. And we start getting to specific documents, I'll be giving you more information on that. It gives you the ability to have different people to do different things on your behalf. But it's really essential for you to select the right person to make the decisions for you. I will frequently say, well, is somebody good to sit down and make medical decisions, but not really smart to make business sense? And the same works the other way. You may not want to have the same person making medical decisions for you as well as making financial. And if you prepare your estate documents, we have the ability to disperse the authority to whoever the person is that's best to make that decision. So we got to also look at what our goals are. And people will frequently say, okay, I don't really know what my goals are, but if you go to an attorney, the attorney can sit down and give you some real life hypotheticals and situations to really help you to think. I'm also an adjunct professor, so I love to sit down and teach while I'm doing things, which I think helps my clients a lot. And frequently, clients want to come in and have all their documents done while they meet with me. And in some cases, I can do that by sending questionnaires in advance. But I can tell you the far best way to really do it is really to have a questionnaire in advance to help you think of things. Meet with a professional versus meeting with a computer and assessing all of those issues and going back and thinking about everything before you really give the attorney what the final answers are to prepare the documents. And the good thing is, frequently when you meet with an estate planning attorney, they will generally be doing it based upon a fixed fee that's agreed upon in advance and not charging you by the hour. So take the advantage to ask the questions, meet with the attorney, and really make sure you get exactly what it is that you want. We have the ability for assets to pass to people or even entities such as charities. By estate planning, we may have the ability to avoid it in its entirety, or at least minimize some of the abilities to pay taxes on your estate as it passes to another individual. We have the ability to take care of any ambiguities or misunderstandings, which will frequently happen when you do what I'll call the online estate planning. We can address issues of administrative cost as to what it takes to administer your estate, and I can go through a variety of documents that can really help you to sit down and minimize those things. And we can also take care of special circumstances. People with MS have different issues than many people. So we can sit down and address those issues and make sure we give authority when needed. We have the ability to control exactly when some of the documents trigger. So you have the ability to still keep your independence for as long as you want as well. So it's really important to sit down and have a very candid conversation with whoever is going to help you prepare your estate documents. Now let's start taking a look at what some of those documents are. A proper estate plan will have a lot of different legal documents. And one that I forgot to put on here, which I want to put on as well, which I'll talk about with you, is we can have our last will and testament. We can have a trust. We can give somebody a power of attorney to act on our behalf. And I'll go in a lot in detail on that one, because that's the one that scares me the most. We can create advanced directives, which are your living will. The DNR form is not one that gets created by an attorney. That's one that really gets created by you and your doctor. And we can have a healthcare surrogate form. Now, the healthcare surrogate form, we really got to make sure that that's one that is what I'll call more modern. Well, HIPAA's been around for a long time. All too many documents that show up in my office by other people are still what I'll call ancient and don't really have the HIPAA language. We want to make sure that we give whoever we're giving the authority the true ability to look at medical records to help make a medical decision. Now let's start taking a look at each of those documents. Now, as we're talking a little bit about attorney prepared documents versus online forms. An online form that you may get may take care of some of your issues, but those are not customized. Because if they're done properly, it's prepared by an attorney, but it's just fill in the blank. It's what I call kind of cookie cutter. So you don't have the ability to truly customize them to say exactly what it is that you want. And I really think that that's the best way to do it. Everything can be totally customized. And when you meet with an attorney, you can do pretty much anything that you ask for as long as it's legal. So take advantage of meeting with a true professional. I say go to a true professional that really does those type of documents. Unless you're in a very small town, you have the ability to really choose an attorney that's a estate planning attorney versus what I call the drive-through attorney, which is somebody that does everything depending upon the person that walks in the door. And that's really not going to be the attorney that has the ability to provide the best of documents. So what is a will? A will is a document which is ineffective. It has no control. It doesn't do anything until the time of your passing. That's why they call it the last will and testament. It's the last document that you have the ability to create to control what you do, with the exception a little bit of a trust. So this is the document that will take effect upon your death and say exactly where your assets go. It doesn't say necessarily where all of your assets go, because some assets you have may pass without ever hitting your estate. Some examples of things like that are your bank account, your insurance policies, and things that may already have a beneficiary designation. That means if you have a beneficiary designation, those documents immediately will pass to whoever it is because the beneficiary has been designated, such as on your bank account. So it's traditionally called a POD, or beneficiary designation, on your account. And that is really a phenomenal form of estate planning. But again, it may not be the best answer because you may just have one beneficiary and you may want to share it with more than one person. So you really got to pay careful attention to what those documents say as well. The will provide a personal representative. That's the person who will be acting on your behalf and administering the estate. Generally, this is the person you want to sit down and use who has the ability to really act and understand finances, because that's really what they're doing. They're controlling the finances of administering and distributing all of your assets. Next, we go to the trust. A trust is an incredible tool, but it's also an expensive tool. It costs more than the creation of a will, but it gives the most freedom of a document you can create. It's what I call giving the person the ability to still control their assets even after they're gone. You can sit down and put in that these things, okay, well, little Johnny or little Jane gets a percentage at 25, another percentage at 30, another percentage at 35. I've even seen trusts that go on till people reach the age of 70. That's what we call a true control freak, but we have the ability to do all of those things. Now, the trust can be in effect while you're still alive. You can transfer assets into your trust and call it a living trust, where we have the ability to sit down and transfer our assets, which is another form of helping you also reduce some of the tax effects by transferring assets into the trust, and then it just goes to that next beneficiary, however that trust is set up. It's an incredible tool, but again, it's called a more costly tool. I do have the ability when I meet with clients at times saying, well, they want to come in and create a trust, and then I sit down and say, well, what is it you're really trying to accomplish? And in some cases, well, I really just want to pass over my home. Well, the one document I forgot to put into my slide today is really one of my favorites. It's called an enhanced life estate deed. And the enhanced life estate deed may sit down and say, okay, upon my passing, my home will flow to Mary or Jane. You can transfer it to many people at the same time, and that they will obtain the ownership of my property. Again, and that's automatically effective. Now, an enhanced life estate, which is also called a ladybird deed, is not really just a life estate, because you still have the ability to sell it, mortgage it, change with your mind at any point in time. Where a regular life estate deed, you need the person that's going to get the remainder after to have also consent to whatever you're doing. So I really don't like doing life estate deeds anymore. I try to convince all my clients to do the enhanced version, because that way you still control your property. And you can also pass off your bank accounts, as I was talking a little bit earlier, by making beneficiary designations. So you may not really need to have a will for too much or your trust if you do things in advance, unless you want to have control. Now, my next document I want to talk about is, for any of you that heard me talk before, is the power of attorney form. This is what I call the scariest document in the world. Why? Because the power of attorney form gives somebody the power to act on your behalf while you're alive, while you're on vacation, at pretty much any point in time, because a person that sees the power of attorney is not going to sit down and see, is this person incapacitated at the time? No. The person shows up with the power of attorney, they can sell your property, depending upon how much authority you give them. They can sit down and go change your beneficiary designations on your insurance policies. They can go to your bank account and clean it out, transfer ownership of your property. They can do everything as if they were you. So you really want to be very careful as to who you give the power to. I have one of my clients who would consider to be a very protective individual, so he will actually create a new power of attorney every time he goes on vacation. And then when he comes back from his vacation, he shows up in my office and tears it up, because he wants to make sure, you please go check to make sure that that I am incapacitated, that this document is really something that I want to give out at that point in time. So you can do things like that as well by kind of keeping it under tight leash. That the POA starts while you are alive, and the only thing that ends it is you terminating it or your death. A power of attorney has no effect after you die. At that point in time, the person that has the ability to act on your behalf is the person that's designated in your will. So all these documents really work in conjunction with each other. My next document, the living will. The living will is not a will. It's really just saying, this is what I want to have happen while I am still alive. It's the one that we call the pulling of the plug. It's a very morbid concept, but it's an important concept to decide. Do I want to sit down and stay alive no matter what? I think that I have the ability that maybe medical things will change in the future and they can sit down and bring me back and make me who I used to be. But this is really the document that says, I do not want to stay alive if I have a terminal illness, I am in a persistent vegetative state, some kind of end-stage condition, and you can choose all three of these, one of these, you can choose whatever it is that you want to say and express to the person, I don't want to continue if I can't take care of myself, and I'm really going to be dying soon. This gives the ability really to sit down and bring in hospice or some other organization to sit down and say, you know what, help me die with my dignity as best as possible. But again, this is not, none of these documents are required. It's a matter of you choosing what you think is best for you. And also, it's important to speak with your family members or your friends or whoever you're going to want to sit down and make some of these decisions for you to know really what it is that you want. It's too late to have the conversation when you're not ready, so have it soon. And next, we have our healthcare surrogate. The healthcare surrogate is a person that you want to choose who's really the most competent to speak with the physicians and act on your behalf. It does not need to be your spouse. It does not need to be your children. It can be a friend. It can be whoever it is that you want to make those medical decisions for you. Depending upon who you go to create the form, we even have the ability to sit down and mark sections in the healthcare surrogate form to say whether this takes effect immediately or whether it only takes effect when I'm not capable of making medical decisions myself. So again, it's important to really understand what the forms say and go over with all of these documents, whoever you're meeting with, to help you prepare them to make sure you truly understand what each of these things say. By going back a little bit to the power of attorney form, you can cross things off on these forms. These forms all can be customized. You don't need to give power over everything. You give power over limited things. It's like I frequently have clients come to me to draw up a power of attorney form just to sit down and help prepare in the transfer of real property because I'm going to be out of town. Do this on my behalf. So these things can be narrow, they can be broad, but every one of these things have the ability to be customized if you meet with a professional and don't just use an online form. And I'm truly not doing this for the purposes of making attorneys more money. It's making sure you get what it is that you want. So really speak with people. Now, another important thing to really go over are if somebody is going to become a fiduciary. What is a fiduciary? A fiduciary is a person that is acting on your behalf. Now, in the power of attorney form, if somebody does things that they weren't supposed to do, like they took advantage and cleaned out your bank account, well, that would be a breach of the fiduciary duty and give you the ability to sue that person. It doesn't necessarily mean you'll get everything back that they have taken, but it does create an obligation on the person that's being given the power to truly act in the best interest of the person who has given that person the power. So if you are giving that person the power, make sure you're trusting the person. If you're the person who's taking that power, understand you do assume liability. So make sure you're really prepared and want to accept that responsibility, because you are legally required to act with care and trust. So that person that gave you the power does have the ability to also sue you. Now, when the power becomes effective really depends upon those documents. Like in the power of attorney form, it's pretty much immediate. Unless you're having somebody hold it back and not give it to them. But technically, once that power of attorney is given, it's effective immediately. In the healthcare surrogate form, it can be immediate if you check the box for that or have it noted for that, or it can be only when you're incapacitated. Inside the will, you have no ability and no authority to do anything until the person passes away. So it's really important to understand who you are and what your obligations are and what your rights are by speaking with the professionals to truly understand those things. Now, when you create these documents, it doesn't mean you necessarily have to share them with the other party also. You can't tell the person that has your healthcare surrogate form, well, if you need it, this is where it's at, and it's kept in my drawer. I'm not giving it to you, though. This is where it's at. You don't want these documents locked up in a safety deposit box. Why? Well, that person may not have the ability to get into your safety deposit box. So truly speak with the professionals when it's coming time to create the documents to know exactly what to do with them, where to keep them, all of those things. Now, let's go over the difference between what happens when we have the documents and when we don't have the documents. If we create our documents, we have the ability to control who's given the power, who has the authority, and we can say exactly what the level of authority they have. In the event you pass away, of course, you have no ability to do anything anymore. And if we don't have a will, somebody's going to petition the court, which may or may not be the person that you wanted. And the court's going to be the person to make the decision as to who has authority over everything. So these documents are really important. I know many clients that have come to me that have children who are pretty much have nothing to do in their life, but the people also tell me they're going to be the first one to show up the minute I pass. So be very, very careful with the authority that you're given. Many documents that are created may also be legally insufficient, and particularly with online forms. Now, there are also, I'll tell you, attorneys out there that may take advantage of people. I hate to say that attorneys are not all professional, but I can tell you, yes, there are some attorneys who are not professional. I had a client that came to me one time because they were moving from Aventura, which is the northern part of Miami-Dade County that I live in, to the southern part of the county. And they came to me saying, oh, I need to change the documents because I moved. And I says, well, why does moving change anything? He says, well, when I moved from New York to Aventura, I met with an attorney and they said, I need to have Florida forms, that my New York forms are not going to be proper. And I unfortunately had to explain to the person, well, I hate to really tell you this. Well, the last time I looked, New York is part of the United States. And as you're still in the United States when you're in Florida, the courts here will still honor those documents that were created in New York. So you don't necessarily need to change things unless you really want to change things. It is good at times to update things, because I actually had a client that I met with who had 2 children and then had 2 children later on. And the will as drafted only covered the first 2 children and wasn't giving anything to subsequently born children. That's something that's standard inside my documents, or it was not standard inside the other person's documents, whether they were created online or whatever. So really, it's important to periodically review them, make sure they say what that it is that you want. But please, and I encourage you all, make the decisions yourself and don't rely upon a court unless your estate is really so simple. What I call the simple estate, in which case it really may not matter, although I still encourage people to do it. We have 2 spouses, and those spouses have children, and the children came from the marriage, and they still want everything to go equally to their children. So in which case, okay, well, if I want everything to go to my spouse, and then upon the passing of my spouse, everything to go to my children, that's what we call the intestate rules that are written inside the statutes. That's the default provision. So ultimately, they would probably get the same result. But then you're going to have one child petitioning and the other child may not agree, and it may be better to still sit down and do your estate documents, but it may not be overly important, but it's still best to make sure you express what your wishes are. And there have been times I've met with clients and they say, this is what I want to happen, and they really don't want to spend the money, in which case I can sit down and say, you know what? The truth of the matter is the default provision by the statute really gives you what you want, so you don't have to create the documents if you don't want to. I still think if you don't care which child, unless you care which child is administering the estate, it may be okay to go without the documents. But I still prefer the documents, but it's still a matter of personal choice. Now, there are some things that we can also create. In the event that somebody becomes incapacitated, we have the ability, and if they're incapacitated, that means we need to have some form of guardianship taken into effect to act on that person's behalf now, because the person can't take care of themselves and act on their own behalf. So you can nominate what's called a pre-need guardian, and you can actually create forms for pre-need guardianship. Or if not, the person has to petition to the court, have medical professionals provide an attestation that the person is incompetent and no longer able to take care of themselves. So we will have what's called a court-appointed guardianship. Or if we have the pre-need form, we've already had the forms and the people can sit down and act on that person's behalf without really having to go through all of the formalities of a court-appointed guardianship. It's a great thing. Most facilities and other people will honor those things by having the pre-need guardianship. So it can be a great tool because now we have selected who the person is. Again, it's very important to know what your documents say because unfortunately we have all gotten older. I still profess to be age 35. I still act probably like 25 at times. But I think anybody that's looking at me right now will know that I'm truly not 35, especially when I have a child who is 35. So at some point I'll claim that he's older than I am, but I can't really do that at this point. So we have the ability to sit down and make these decisions, act with a professional so that we really can have these things taken care of. In the creation of documents, really, as I said earlier, choose wisely. There are people that are good with medical information. There are people that are good with financial information. Let the people who serve that role best do it as best they can, and make sure you choose the people to make those decisions. Have people that'll be great to meet with your financial advisors. Make good investments on your behalf. Not pay themselves an exorbitant fee for taking care of those things. When it comes to medical decisions, it's good to have somebody who has the ability to act with your insurance companies, maybe protest bills by some of the medical providers. Understand if the person is young and still working with the Family Medical Leave Act. Deal with all of those decisions. Deal with the doctors to make medical decisions. You can't have people that are great in doing everything. You may have people, in particular when it comes to the living will and pertaining to being your healthcare surrogate, that could never honor your wish. I can tell you I have had people that sit down and say, my spouse will never pull the plug on me. They will make sure that I never pass away, even though I would want to pass away. Well, we have the ability to choose the person to make those decisions. That may not be your spouse, it may not be your child. I have 2 children that may very well be listening to this, and I think it'll be far harder for my daughter to sit down and do that than it would be for my son. I'm not saying that my son is cold or anything along those lines, but my son is very much like me that sits down and say, I will honor the person's wish regardless of whether my wish agrees or doesn't agree. My daughter, I started having that conversation, which says, no, I would always honor your wish, but she's the more sensitive of the 2. Stuart knows them both, and I think we'd attest to pretty much having a similar opinion to Nate on that one. And let's move on. Documents versus the roles. The legal documents are what's required to give the person the power to assume the role. Again, without the document, it goes to the court. The documents can also control the level of power. A person like me who is a control freak is very, very specific into what powers I will and will not give. I can tell you I have yet to sign a power of attorney to give anybody a power to act on my behalf on anything. Again, I'm a control freak. The title that you give the person doesn't necessarily control the power. It's whatever the document says. Giving somebody a power of attorney to sit down and fill out a form or sell your house doesn't mean the person can sit down and go to your bank with that power of attorney. Again, it's limited to whatever the document says. And again, that power is being given to this specific person that is noted inside of it. Or in the case of an entity, it might be more than one person. Because yes, you do have the ability to have a financial institution act as your trustee of your trust, and it's frequently done with some very high net worth individuals. But I can tell you, they don't move fast. Why? Because then it goes through the legal department of that financial institution before anything even happens at that point in time. So I've had closings and things like that where trusts were buying property, and it is a total nightmare when the trust has a financial institution acting as the trustee. Again, another reason to speak with a professional to give you advice on those things. Now, what is a caregiver? The caregiver really has the obligation to honor that person's wishes. So choose the person who will honor your wish. I tell the caregiver, if you can't respect the decisions of that person, do not accept the role. There's no legal requirement for anybody to assume a role that they do not want. Even if the document says you've been given that power, you have the ability to say no. Why, when I create documents, I like to have my clients list alternatives. This is my personal representative, but if that person dies or refuses to honor the role, then it's this person. And if that person dies as well, then it's this person. You have the ability to list these people in options and in sequence. You can give people joint power. So I want these people to act as co-trustees or co-personal representatives or co-healthcare surrogates. I frequently will do that. I will put a caveat inside of it that each of them still has the ability to act independently of the other in case they can't get both together. Again, you can draft the documents as you want, and it's important to give power to more than one person because we never know who's going to go before us. I had the misfortune of getting information from a friend just recently that their 20-year-old son had passed away. It's not a good thing, so we never know what's going to happen. So it's important to have more than one person listed for each of the roles. You may only have one, but if you can come up with a second, even if you can come up with a third, those are good things to have. Who can you select for these different roles? You have to select somebody who has reached the age of majority. You cannot have minors serve in this capacity. You do not need to have a family member. You can have a friend. In some cases, it's a little bit more tricky, like in a will. You need to choose somebody that if somebody is a non-immediate family member, the person needs to reside in the state, who's here for the state of Florida. So you can't have your best friend from the New York act as the personal representative of your estate in Florida. So again, important reasons to talk with professionals to help you draw up the documents. And realize that a lawfully appointed person can overrule your family. So choose wisely and know who can serve in these different roles.
Okay, that's good. We have a bunch of questions that came in. Thank you very much for doing this presentation. Everybody give a virtual clap to Craig. I can't hear you, so don't worry about it. You could whistle, you could jump up and down on your head. It doesn't matter, I won't see you. And by the way, that comment you made about Acting 25, wouldn't go a day without it. I wish my body would do it though. All right.
We all wish that our bodies were still the way they were in many cases at the age of younger, especially my shoulder.
The age of younger, exactly. All right, Mr. Craig, let's start with some questions that people had for you. The first one is, what would a reasonable fixed fee be for the planning of services? Which services?
And that's going to be my next question, is saying the question is, which documents? I mean, you can create a will for one price. I mean, so the question is really what the package is and what everybody need. I mean, I would say that, and also I would say the fees really vary based upon areas. In the larger cities, of course, I see that the prices are higher, and people say, well, why does it make a difference? Well, I can tell you the overhead of an office in a small town is going to be far less. What you pay your staff in a small town usually is far less than what you pay in the big cities.
Right.
So I'm saying I've seen fees being done for as little as $1,250, which I wish I could do. I wouldn't be able to afford to give the whole package for those kind of prices. I have seen financial documents that were put together for in excess of $25,000, which gives me palpitations. But I can still remember, I also know now what my hourly rate was versus if I was practicing still in the big firms like I did in the old days. I mean, I have my law clerk that I taught how to practice right now that's billing out at $1,200 an hour. And I sit down and I scratch my head when I couldn't dream of charging a price anywhere in the reasonable vicinity. So again, I wish I could tell you if you gave me an idea of areas. I'm saying I would say in a large city, if you have a normal estate, documents are probably going to be around the area of $3,500 in a big city, probably more $2,500 in a smaller city for a package deal if it's a relatively simple estate. When you add in the trust, the price goes up because a trust is a complex document to put together because you're putting in a whole bunch of other factors. But for a simple estate, $1,500 to $3,500, depending upon where you go, I would say would be a reasonable fee. But getting to the $1,500 is difficult in the larger cities.
So you'd be surprised though about the smaller towns with the big name doctors in these small rural areas. They actually charge more than in the big cities because there's one of them for the whole area, and they just know that they could get more for it. So they do. They built their own system. All right. So the person that wrote the question initially came back and wrote that they want to know the reasonable fixed fee in a city for looking at to get a trust or a will.
In a big city or a small city?
Big.
In a big city, I would hope that the fee would really be no more than $3,500 unless your trust is complex. Because you're putting all kinds of caveats and restrictions and you're saying, okay, they're getting some at 25, 35, 45, all the way up to age 70. Well, of course, the fee is going to be far higher because you're putting a lot of caveats into it, in which case maybe you're going to get up to around $5,500 or $7,500 in a big city.
Right.
But I would encourage you to shop around. Many lawyers give free consultations, some charge, but you may want to pay the consultation fee to make sure what you're getting into in advance. Pay a $200 consultation fee to maybe 2 people and you get your fee to come down to half. It's worth your while.
Okay. So somebody just wrote, the advanced healthcare directives are state specific. If you are hospitalized in another state, will your directive from that state you live in be honored?
It should be because we still do live in the United States. If you create documents in the United States, one state should honor the wishes of what you have from another state. I can tell you I've seen times when people have had objections to it, but that's not the way our system is supposed to work. In many cases, I mean, the important thing I'd say of the advanced directives and things along those lines, you do have the ability at most facilities, I will say with the caveat of non-religious institutions, to sit down and create the documents at the time of admission. The bigger problem comes, unfortunately, it's sometimes we're picked up by fire rescue or whatever else it is. You don't have the ability to have your directives in place at the institution. That's really when it's vital for somebody to be able to sit down and show up with your documents. That's why when you go to meet with your doctor and you have your DNR, they tell you, okay, have it in this piece of paper and it's got to be in this color and it should be on your refrigerator. So when the paramedics come in, they see the form, they see that you have a DNR. Otherwise, guess what? They're going to sit down and not honor that wish because they don't know that wish exists. In most cases, they will come in and they really do go look at your refrigerator because that's the place that doctors tell you to post it.
Yep.
Put your wishes and make sure they're done correctly.
Yep.
But again, if we live in the United States should honor the form from New York and Florida and vice versa. The lingo may change, but they're very capable of understanding what the documents mean.
Thank you. So for those online that do not know what DNR is, this is do not resuscitate. Okay, so when you hear Craig talking about this, you'll know what he's talking about.
Thank you.
The next thing.
I have a habit of using lingo and forget.
Say that again?
I sometimes use the lingo and forget that to put the caveat on.
Of course. That's why they have me, right? Okay, I have to have a role in life. It's going through the acronyms. Okay, so going further though with the DNR is, if you talk about that, the paramedics finding a person in their home. What if something happens out on the road somewhere? There's no DNR attached to the dashboard of the car. There's no DNR attached to the person's leg, that they might be walking down the street. So how is this resolved for a person that is not at home and a medical emergency comes up?
I'd be curious to go and see if you go on Amazon if they have DNR bracelets. I really don't know.
Right. I actually know of a person that tattooed this wish to his ankle to go home and see his note on his refrigerator. See refrigerator is what it says. Law, see refrigerator. Yes. Okay. All right. Next, person writes, maybe I'm just dense, but what is the advantage and need of a trust and a probate?
Okay, what probate is the administration of your estate. If you have assets that you have that do not pass outside of your estate, then you go through probate. And probate, that is where the will comes into effect. But I can tell you, I have prepared many people with their estates where there has been no probate, because everything was taken care of and there was no need to go to the court. So many people will pass away and there'll be zero probate proceeding taking effect. So probate is just the administration of the estate to take care of dispersing your assets after you pass away. A trust is only important if you want to have some control after you pass. That is really what the purpose is. The only other purpose is taking care of transferring assets, again, outside of probate, maybe to avoid taxes. We have the ability to do some of those things as well. So it's really a matter of preference, matter of what your estate has. Very, very frequently, I take care of everything and meeting with my clients, as can most competent attorneys that take care of estate planning, to make sure there really is no need to ever probate. By talking just with my immediate family members, there was no probate of my parents' estates, no probate of my in-laws' estates, because things were done in advance to make sure there was no need for it. And that's really what my goal is, to sit down and help people avoid the need of having probate take place. Probate takes time. I've had probate estates that have taken 6 months. I've had one probate estate that took over 2 years. I can tell you in the case of a very, very wealthy individual, the probate went on for nearly 20 years with a series of different attorneys because of all the infighting between all the different family members. Again, everything is a matter of what fits the person's needs, and consult with an attorney. An initial consult with an attorney should not be terribly costly to go over and figure out what's best for you.
Okay, so a person brought up to me that he's going through divorce, and I have it all right now. He's going through divorce, and he's concerned that if something happens during the entire procedure in his state, because evidently things take greater than a year for it to go through, what if something happens to him now, okay, and with regard to his current thought of what he wants done with his money, yet everything was signed before the divorce proceedings, and what happens with all of that?
That's really the question that needs to be handled with the family law attorney. If you don't have a prenuptial agreement or some form of postnuptial agreement, unfortunately, your spouse will still have control over many of your things. Generally, there's what they call a stay still order. I can't remember, a standstill order that comes into effect when you file your divorce proceeding. So the only thing you're really going to have the ability to control is money earned after the divorce was filed. So there's unfortunately limited control in case you pass away during the pendency of a divorce. But really, that's where your family law attorney needs to get together with an estate planning attorney to really figure out what's best for you and in what particular state you live in as to how to take care of those things.
Gotcha, thank you. Following along that line, the next question that he had was, what happens after the divorce to get the documents nullified so that way he can rewrite everything?
You can sit down if you have a advance directive or something that's in place while you are still married. As far as I know, in most states, there should be nothing that should prevent you from terminating your power of attorney, terminating any of those things that were created during the marriage. So again, you can sit down and delegate new people. Normally, when you create a new power of attorney form, that voids the one that was before. Same thing with your healthcare surrogate form. Unless the court sits down and somehow has a standstill order that precludes that from taking effect, but it shouldn't. At least I don't know. I would hope not. Why should your spouse that you're in the middle of a divorce for have the ability to make your medical decisions?
Right. I would imagine that to be a problem. All right. Next, going to power of attorney. Everybody that's online, I know you got a lot of questions there. I also had a lot of people write in questions, so I have to go through some of these as well. Person writes about power of attorney. How many power of attorneys are permitted if there's more than one sibling?
Generally, I like to have one that we know is effective. I've had many clients that have created more than one. That way, any of them can go there, but it's being in that case, the first one that shows up is going to be the one that's the banker, whoever is going to honor. You can't sit down and make a joint power of attorney where you require decisions to be made jointly between more than one person. In many cases, that's the best choice, that it's A and B. So you can create multiples, but the bank or whoever goes to is not going to look at and see which one is effective. It's going to be whoever shows up first.
Gotcha. All right. Thank you for that. Next, going back to the more than one sibling, I didn't quite understand this, but if there's multiple siblings and one of the siblings feels that he or she is a control freak and wants to make sure that he or she takes care of everything and doesn't let the other brothers and sisters take care of what the parents wanted, is there any way to control that?
The only way really to control that would be to sit down and make sure that that person doesn't get the power of attorney. Otherwise, if you feel somebody's not acting in the capacity of what the person would truly want, you do have the ability to sit down and go into court and try to get some kind of guardianship or something appointed and deal with it, unfortunately, in the legal way.
Right. And going back to that one more time, and then we'll go on to something else, is that regarding the banking that you were just talking about. So if you're saying more than one child has power of attorney and one of them happens to get into the bank first, is there no way for the others to desensitively look or ask for how much is in the bank without upsetting the first one? I mean, how do you go about that?
You can show up with your power of attorney form, and what the bank is probably going to do is send it off to the legal department and see which one's dated later. And if you find one that's dated later, then the bank should honor the one that was dated, the latter one versus the earlier one.
Okay, thank you. Next line of questions. how does a person pay for nursing home costs if they cannot afford nursing home costs?
Unfortunately, not really my legal expertise. I generally refer those people to an attorney that's called an elder law specialist who can help that person get qualified for Medicaid.
That was the question. That was what I pointed the person to, but I wanted you to say that yourself. Okay, great.
That's an elder law attorney, and there are, in many cases, you can look them up, but try to get somebody who's truly board certified in elder law to make sure they truly know what they are doing. It is a true specialty. I have ones that I refer to in different areas because it's hard to find people that truly are experts in it.
Okay, thank you for that. Next one has that different children are in different states, and even though the parents wanted to be buried in one state, somebody's claiming that they want their parents buried up north with them, and then that has now started another war. So how does something like this get resolved?
The attorneys do, I mean, the person does have the ability to create directives as to where they choose to be buried. You can sit down and make your advance, you can make arrangements in advance, but I've actually known some kids that have sat down and just sat down and said, I don't care that they have burial plots that are over there, I'm moving them over here. You do have the ability to sit down and specify in a document where it is that you want to be cremated, buried, handle those facilities and make those pre-need arrangements. Again, that is another form that we can create, and I guess, yes, I will add that to my PowerPoint for the next time I give the presentation on that one as well.
Okay. Another one about grave sites is that parents originally had grave sites in one state. They moved to another state and they decided to get buried in that state. How does the family sell off the grave sites that are in the first state?
That typically I tell them they have to sit down and contact the facility of where you're at, and hopefully they can help you make arrangements to sell it. You can look at the contracts, they may be freely sellable, and you can go sit down and pretty much put it on eBay if you wanted to, if they're freely assignable. But again, that's contract specific. It's not state specific.
Okay, thank you for that. Next one writes, how do the tax advantages of a trust work?
In each case, this is state law specific and U.S. government specific. There are different laws that are in effect, but you do have the ability to transfer assets into the trust. There may be a taxable consequence to that when you transfer it. So again, you have to refer to your tax attorneys in your particular state or your accountants to deal with some of the tax issues. But once we make that transfer into the trust, if that transfer was non-taxable, then it goes on to the next individual, again, tax-free. So again, you have to sit down and look at your tax individuals from your particular state because each state's laws are different.
Great, thank you. For those that are asking how they can get a copy of this presentation, well, like I say at every event we do, everything is being video recorded, okay? And so it will be on our YouTube channel soon, okay? And you'll just, if you want to know what's on that YouTube channel and when things get published, best to do is go onto that YouTube channel and register for it, okay? Sign up for it so that way every time we publish something new, you will get an email that says what was just published, and you'll be able to watch whatever you want at that time, okay? And if you don't know how to do that, just visit our website, msvn.org, and click on our YouTube links. Next question. Next question we have, I always want to say their name, but I know not to. All right, the next one is, after setting up a trust and will, if I want to pass on something like a painting to someone, do I need to change the will or the trust to specify this?
Well, the trust only holds whatever assets you transfer into the trust. So it's scary and it's really sad. I can't tell you the number of people that have paid lawyers to create trust but never fund the trust. And what I mean by fund the trust is meaning putting the assets in to be titled by the trust. I mean, your bank accounts, you have the ability to transfer those. Your securities portfolios, you have the ability to transfer those into the trust. If they're not transferred into the trust, it doesn't mean anything because then you may end up in probate anyhow. And it's really scary as to the number of times people hire lawyers to create documents, but if they don't carry through with it, it's ineffective. So if you don't want your painting or your artwork or your 1957 Chevy to go into the trust, you have the ability. Sorry, I'm using a car reference here. That's a very valuable car for people that don't know. You have the ability to sit down and transfer things independently or through the trust. You can even put things in the trust and say this goes here and that goes there. So again, everything is what you want, and if you express to the attorney what you want to do, and even once you put something in the trust, that doesn't mean you cannot transfer it out of the trust. If it's a revocable trust, be careful with irrevocable trust. I really don't like those unless you're really a multi-millionaire, because again, then you can't make modifications to it easily. So again, lots of things can be done. I can speak for hour after hour after hour on things. So that's why I say consult with a professional. As the expression one of my attorney friends hates every time I use it, don't rely upon Dr. Google. Google doesn't give the best advice, nor does Wikipedia. So figure out what it is that you want to accomplish, and pretty much anything can be accomplished by putting the proper wording into the documents.
Okay, so if somebody really cannot afford the documents and they have certain items in their home that they want to leave to a specific person, isn't it also okay to write out something and just have it notarized so that way they can just handle it like that? Like, hey, there's a grandfather clock on the wall and I want to make sure that Peter gets this.
Unfortunately, it doesn't work that way, at least not in the state of Florida. Holographic wills that are just handwritten wills and documents like that are not enforceable in the state of Florida. In some states, they may very well be. So again, that's state law specific, but in most cases, a document that just expresses a wish is not really going to be honored in most states.
Okay, thanks.
I mean,
next one.
Family members do get along. I have had a grandmother that sat down and put little stickers on things that this goes here and that goes there. As long as the family members don't fight, things seem to go where they want supposed to go. But that doesn't mean that's necessarily that the family members are going to honor your wish.
Got it. Thank you. Next one writes, can elder law attorneys help with the preparation of various documents?
Okay, I'll presume what they mean by that is most elder law attorneys are also estate planning attorneys. So that means the elder law attorney can take care of your advance directives, your will, your trust, and also help you get qualified for Medicaid. In most cases, I will call them the higher form of an estate planning attorney. That doesn't mean that all elder law attorneys do all those other documents, but I would say probably 99% of them can sit down and help you with all of your estate planning, as well as helping you get qualified for Medicaid.
Okay, thank you. A question outside what we've been talking about, but maybe you still can answer this. If someone personally owes the Small Business Association or the IRS, for example, can the feds garnish their Social Security benefits?
It really depends upon what the loan is. Most SBA loans are specific to the business and don't flow through to the individual, but there are some larger ones that are done that have the ability to flow also to the individuals. The COVID SBA loans, at least most of the ones that I looked at, are more on, I'll call the smaller side, even though most people may not say the numbers are smaller, and they generally only go to the business. They don't go with personal guarantees. So again, it's going to depend upon the document itself as to what they have the ability to do. I know many larger SBA loans that I've been involved with that also affect personal guarantees, and yes, they can garnish. They may not be able to garnish your Social Security because there are certain exemptions that are there, but again, it all depends upon the contract, because an SBA loan is a contract and the terms of the contract will govern.
Okay, same thing applies then to, like, if somebody has a small corporation or an LLC and they pass and there are taxes due, can the government come after that, or do they go after the family first?
It really depends again as to what the loan is and whether it's guaranteed or not individually. All government loans are different depending upon what the terms of the loan are. So can they? Maybe.
All right, next one. Question is, after setting up a trust and will if I want to pass on something like, oh, that was the same one. Never mind. I forgot to erase it. Next one. If all the healthcare documents and POA are in good form, why would a guardianship be needed?
Depending upon the documents that you have. I mean, the guardianship is taking care of the individual. And in many cases, if you don't have the proper documents in effect, they may not let you, with your healthcare surrogate form, also make decisions once the person becomes incapacitated. It should not happen, but I have seen cases where facilities are asking for the guardianship, which is why in many cases, in particular, I've done this with many patients that have specific ailments. I've also done, as part of my documents, the pre-need guardianship form.
Okay, thank you.
It's crystal clear and harder for the facilities to argue. This unfortunately does happen when facilities may not want to release a patient. And I have seen cases where facilities seem to want to hold on to that patient to continue to earn money. I hate to really say that, but I have had cases like that where I've had to write some nasty letters for people over time.
Okay, thank you. Person wants to know how he would hide his assets from his spouse that he doesn't want them to know. I'm reading this. How much he's making and wants to.
I will say, talk to an attorney. I am not giving advice like that because that's not something that I would ever do.
Gotcha. All right, next one. My bank will not honor my DPOA unless it gives my agent the power to change beneficiaries. Is this unreasonable?
In my opinion, yes.
Okay. 2 more questions and then you're done for the night unless somebody starts writing questions. Can you limit the power of attorney to only specific tasks, like withdrawing only specified amounts of money for necessary items, or getting into your computer to pay your bills while you are too sick to do that?
Can you? Yes. Well, the question is, will the bank honor that? Probably not. Because the bank is not going to want to assume that level of detail and checking on things.
Okay. Next, how do you find a good estate planning or elder law attorney?
I would say first, talk to friends that have used them that may be in the area. I would say you can do your computerized legal research, such as Google and check reviews, although many of those things I find have been falsified or by hiring professionals to do this over time, although Google does try it. You can call the local bar association and try to get recommendations because they can probably guide you towards attorneys that are certified in the areas. Not saying that necessarily they are better, but at least we know that they have more knowledge than others. But your best source really is by contacting friends inside of the area, because most friends have dealt with it or know somebody that has dealt with it.
Okay, thanks. So if 3 more questions popped up, they must have known we were almost there, right? First one writes, this question is for Stuart. The NMSS Navigator, National MS Society Navigator, can the National MS Society Navigator recommend or indicate family law attorneys, et cetera, et cetera? I doubt it. Okay, I doubt it. I think that they will tell you that you need to find this on your own because they do not want to be responsible if anything goes wrong. Okay. How does the attorney say about that?
I've never seen organizations like that give referrals out at all.
Exactly. Okay. If a person, true question. If a person doesn't have children or close relative or someone they want to name as a POA, who should you name?
If you don't have family and you don't have friends, it's really, I can't sit down and say who that you can go to because I wouldn't want to give that power out to anybody, unfortunately. You don't want to sit down and have somebody that you're not trusting. I mean, that the POA form is, I say that, it's a very, very dangerous document. And I have dealt, unfortunately, with cases where people have been cleaned out. I mean, I have a person that I know that went on a business trip, and when they came back, there was nothing left. You can clean out a person very, very fast.
Yep. All right, next one.
So it's even more difficult to a non-extradition country. So they're gone.
You know, everybody, if you hear me over talking Craig, it's because he has like a few second pause in his thoughts many times, and I think he's done with his whatever he's saying, and so I go to ask the next question, and then he just continues. So I apologize for that, but not to Craig. I do to you.
So don't feel bad.
That's right. All right. Next one writes, a friend's caregiver embezzled money after she gave them power of attorney. What actions can she take to get her money back or justice?
In most areas, you can sit down and go to the Economic Crimes Division of your local state attorney office, which is a great place to go. In many cases, they have people that deal particularly with the elder law abuse statutes that exist in most states as well. If you can't get them to do it, which is unfortunate, in many cases they'll say no. Unfortunately, you have to hire an attorney and go try to get a judgment and then go collect upon that judgment. The world is not perfect. That's why I call these forms very dangerous.
Are you done? I'm joking. All right. If there are annuities with children as beneficiaries, do they have to pay bills from that?
If the beneficiary designation takes effect, in many cases, the creditor is going to have a very difficult time collecting. But if they find out about it and they find out the money was taken and there was still money in the account that should have been used to pay liabilities, while I haven't seen it happen, it could happen. But there's nothing, if you don't have money, that requires your children to pay your bills. So they can't come after your children to make you pay their bills unless they guarantee something. So if there's no money in the estate, there's really nothing to go after. And in many cases, I have seen kids that have gone to the accounts and used the beneficiary designation, taken the money, and then the creditors have never gotten paid. So it's chances and things that do happen, but they could technically be gone after for the amount of money they've taken, but not their own personal money.
Okay, next. It's going to be like second to last question, I think. If your former spouse handles most affairs currently, will any notarized documents be null and void if they were to remarry?
No, but traditionally those powers of attorney and all those things, once you get divorced, typically terminate. So if you re-signed it afterwards, it's going to be your obligation to go sit down if you find out that you don't want them to do it anymore, to go terminate those documents. But it's not going to happen automatically just because that person got remarried.
Okay, thank you. And the last question is something that I was going to turn around and put into another way. Person asks if you're taking clients. I was going to say, and Craig, if anybody needs to contact him, can just send me an email and I will forward it for you to Craig.
Or you can go rewatch the things, and my information is posted on the very first or second slide. So
That's
the information is there, it's available. So I'm glad to help anybody that I can possibly help. Yes, I've helped people from the organization. And in many cases, when you do call my office, if you reference MS Views and News, I can tell you my assistant does know the name of the organization, and you did get treated with a little bit more of kitten gloves.
Great, thank you. And a person just wrote, this was very helpful and informative. Thank you very much, Craig.
All right, now the only caveat before you start talking again, I caught you right before your lips were starting to move again. I do put the caveat on all this information. I am only licensed in the state of Florida. I do not practice law in any other state, and I cannot give legal advice for any states with the exception of the state of Florida, or represent anybody from outside of the state of Florida, unless you have assets here in Florida that you want assistance with.
All right, and that's it. So let's call it a wrap for the night. Let's thank Craig for taking time out of his day to do this. And I look forward to seeing you all again at another event soon. Okay, thank you. Bye-bye.
Thank you.